A state of the United States of America is one of the 50 constituent political entities that shares its sovereignty with the United States federal government. Due to the shared sovereignty between each U.S. state and the U.S. federal government, an American is a citizen of both the federal republic and of his or her state of domicile. State citizenship and residency are flexible and no government approval is required to move between states, except for persons covered by certain types of court orders. States range in population from just under 600,000 to over 38 million. States are divided into counties or county equivalents, which may be assigned some local governmental authority but are not sovereign. County or county equivalent structure varies widely by state. Kentucky, Massachusetts, Pennsylvania, and Virginia use the official title of Commonwealth rather than state. State governments are allocated power by the people through their individual constitutions. By ratifying the United States Constitution, the states transferred certain limited sovereign powers to the federal government. Historically, the tasks of law enforcement, public education, public health, transportation, and infrastructure have generally been considered primarily state responsibilities, although all of these now have significant federal funding and regulation as well. Over time, the U.S. Constitution has been amended, and the interpretation and application of its provisions have changed. The general tendency has been toward centralization and incorporation, with the federal government playing a much larger role than it once did. There is a continuing debate over states' rights, which concerns the extent and nature of the states' powers and sovereignty in relation to the federal government as well as the rights of individual persons. Debates over states' rights were a contributing factor to the outbreak of the American Civil War. The United States Congress may admit new states on an equal footing with existing ones. This last happened in 1959 with the admission of Alaska and Hawaii. The U.S. Constitution is silent on the question of whether states have the power to leave or secede from the Union, but the U.S. Supreme Court has ruled unilateral secession to be unconstitutional, a position driven in part by the outcome of the American Civil War. U.S. map. Click on a state on the map to go to its main article. Federal power. Since the early 20th century, the Supreme Court of the United States has interpreted the Commerce Clause of the Constitution of the United States to allow greatly expanded scope of federal power over time, at the expense of powers formerly considered purely state matters. The Cambridge Economic History of the United States says, on the whole, especially after the mid-1880s, the court construed the Commerce Clause in favor of increased federal power. In Wickard v. Filburn 317 U.S. 111, the court expanded federal power to regulate the economy by holding that federal authority under the Commerce Clause extends to activities which may appear to be local in nature but in reality affect the entire national economy and are therefore of national concern. For example, Congress can regulate railway traffic across state lines, but it may also regulate rail traffic solely within a state, based on the reality that intrastate traffic still has an impact on interstate commerce. In recent years, the court has tried to place limits on the Commerce Clause in such cases as United States v. Lopez and United States v. Morrison. Another example of congressional power is its spending power, the ability of Congress to impose taxes and distribute the resulting revenue back to the states. A classic example of this is the system of federal aid highways, which includes the interstate highway system. The system is mandated and largely funded by the federal government, and also serves the interests of the states. By threatening to withhold federal highway funds, Congress has been able to pressure state legislatures to pass a variety of laws. An example of this is the nationwide legal drinking age of 21, enacted by each state, brought about by the National Minimum Drinking Age Act. Although some objected that this infringes on states' rights, The Supreme Court upheld the practice as a permissible use of the Constitution's spending clause in South Dakota v. Dole 483 U.S. 203. Governments. States are free to organize their individual governments any way they like, so long as they conform to the Constitution of the United States. Constitutions in practice. Each state has adopted a three-branch system of government generally along the same lines as that of the federal government, though this is not a requirement. Executive in all of the U.S. states. The chief executive is called the governor, who serves as both the ceremonial head of state and administrative head of government. The governor may approve or veto bills passed by the state legislature, as well as push for the passage of bills supported by the party of the governor. In 43 states, governors have line-item veto power. Most states have a plural executive in which two or more members of the executive branch are elected directly by the people. Such additional elected officials serve as members of the executive branch, but are not beholden to the governor, and the governor cannot dismiss them. For example, the Attorney General is elected, rather than appointed, in 43 of the 50 U.S. states. Legislative. The legislatures of 49 of the 50 states are made up of two chambers, a lower house and a smaller upper house, always termed the Senate. The exception is the unicameral Nebraska legislature, which is composed of only a single chamber. Most states have part-time legislatures, while 6 of the most populated states have full-time legislatures. However, several states with high population have short legislative sessions, including Texas and Florida. In Baker v. Carr and Reynolds v. Sims, the U.S. Supreme Court held that all states are required to elect their legislatures in such a way as to afford each citizen the same degree of representation. In practice, most states choose to elect legislators from single-member districts, each of which has approximately the same population. Some states, such as Maryland and Vermont, divide the state into single and multi-member districts, in which case multi-member districts must have proportionately larger populations, e.g., our district electing 2 representatives must have approximately twice the population of a district electing just 1. If the governor vetoes legislation, all legislatures may override it, usually, but not always, requiring a 2/3 majority. In 2013, there were a total of 7,383 legislators in the 50 state legislative bodies. They earned from $0 annually to $90,526. There were various per diem and mileage compensation. Judicial states can also organize their judicial systems differently from the federal judiciary, as long as they protect the federal constitutional right of their citizens to procedural due process. Most have a trial-level court, generally called a district court or superior court, a first-level appellate court, generally called a court of appeal, and a Supreme Court. However, Oklahoma and Texas have separate highest courts for criminal appeals. New York State has its own terminology, in that the trial court is called the Supreme Court. Appeals are then taken to the Supreme Court, Appellate Division, and from there to the Court of Appeals. Most states base their legal system on English common law, with the notable exception of Louisiana, a former French colony, which draws large parts of its legal system from French civil law. Only a few states choose to have the judges on the state's courts serve for life terms. In most of the states, the judges, including the justices of the highest court in the state, are either elected or appointed for terms of a limited number of years, such as 5 years, eligible for re-election or reappointment if their performance is judged to be satisfactory. Relationships among states. Under Article 4 of the United States Constitution, which outlines the relationship between the states, the United States Congress has the power to admit new states to the Union. The states are required to give full faith and credit to the acts of each other's legislatures and courts. which is generally held to include the recognition of legal contracts and criminal judgments, and before 1865, slavery status. Regardless of the full faith and credit clause, some legal arrangements, such as professional licensure and marriages, may be state-specific, and until recently states have not been found by the courts to be required to honor such arrangements from other states. Such legal acts are nevertheless often recognized state to state according to the common practice of comity. States are prohibited from discriminating against citizens of other states with respect to their basic rights. Under the Privileges and Immunities Clause, under the Extradition Clause, a state must extradite people located there who have fled charges of treason, felony, or other crimes in another state if the other state so demands. The principle of hot pursuit of a presumed felon and arrest by the law officers of one state in another state are often permitted by a state. With the consent of Congress, states may enter into interstate compacts, agreements between two or more states. Compacts are frequently used to manage a shared resource, such as transportation infrastructure or water rights. With the federal government, the states are guaranteed military and civil defense by the federal government, which is also required to ensure that the government of each state remains a republic. 4 states use the official name of Commonwealth, rather than state. However, this is merely a paper distinction, and the U.S. Constitution uniformly refers to all of these subnational jurisdictions as states. For all of these purposes, each of the 4 above-mentioned commonwealths counts as a state. This is not to be confused with the 2 commonwealths of Puerto Rico and the Northern Mariana Islands, which are both territories of the United States.